Welcome back to the deep dive. Today we're buckling up. It feels a bit like driver's ed, you know, but for the financial markets.
That is a perfect analogy, actually.
Right. Usually we take this wide lens, we look at big trends, but today we're zooming in, like microscopically in, on the bedrock of the whole Indian financial system. We're talking about the rules of the road.
Yeah. And if the stock market is the superhighway, with Ferraris and heavy trucks all speeding along, the regulations we're about to discuss. They're the lane markers. They're the speed cameras, the guardrails that keep the whole thing from turning into just a twisted pile of metal.
Exactly. And I know legal chapters can feel a bit dry. We're looking at Chapter 18 today, key regulations. But for anyone out there preparing for the NISM Series XA certification.
Or just anyone who wants to work in this industry, really.
Right. This isn't just paperwork. This is the difference between having a career and having a lawsuit.
It really is. And the stakes here are so high, we aren't just talking about, best practices. We're talking about the law. If you violate these, you don't just get a bad grade on an exam. You get banned, you get fined, or worse.
So the goal today is to strip away that dry legal language.
We're not just going to read statutes. We're going to translate all of this into basically survival skills for the market.
Okay, so consider me the student in the passenger seat then. I'm ready to learn, but I am looking at this stack of acts. You've got the SEBI Act, SERA, insider trading. It's a lot of legalese.
And I'll be the instructor, with my hand on the emergency brake just in case. My role today is to translate that legalese into market reality. We're going to cover the Securities Contracts Regulation Act, the SEBI Act, insider trading, and this is the big one, we are going to go very, very deep into the investment advisors regulations of 2013.
And that's the core of the exam, isn't it?
It is the heart and soul of this entire module. So before we even, start the car, so to speak, let me ask you something. Do you have a notebook handy? Or at least a dedicated note-taking app open on your phone or something?
I do. Why? I was doing math?
Not math, but memorization. There are specific numbers, time limits, client caps, things like that in this chapter that are pretty much guaranteed exam questions. When we hit them, I'm going to flag them. You need to write them down.
Got it. Pen is poised. So let's start at the very beginning, the bedrock. Section 18.1, the Securities Contracts Regulation Act, or SCRA 1956.
The SCRA, and that date, 1956, is important. It tells you this predates almost everything we think of as the modern market.
So what was its purpose back then?
Think of the SCRA as the Anti-DABA Trading Act.
DABA trading, you mean the illegal off-the-books stuff?
Exactly. The word DABA literally means box. In the old days, and let's be honest, even in the shadows today, people would trade stocks completely off the books. No exchange, no official record, just you and me making a bet on a price movement.
The Wild West.
It is the Wild West, or the bucket shop model. So the SCRA was enacted specifically to prevent, and this is the official term, undesirable transactions. Its main job is to say, look, if you want to trade securities, you do it here in the light.
On a recognized platform.
Exactly, on a recognized platform.
So this is what gives the government power over the stock exchanges themselves, like the NSE and BSE.
Correct. It gives the central government regulatory jurisdiction over stock exchanges, and that includes three key things. First, recognition. You can't just open the deep dive stock exchange in your garage.
Right.
You need government recognition. It also covers supervision of those exchanges and the rules for listing securities on them.
Okay. And the text mentions a key definition here that seems foundational. Does a transaction between two people is, at its core, a contract.
Right. And that's so important legally. When you click buy on a share and I click sell, we're entering into a contract. The SCRA is the law that specifically governs that contract. If we just, shake hands in an alleyway and trade a stock certificate, that's not a recognized securities contract under this act.
So it's about creating a monopoly of trust.
That's a great way to put it. Legitimizing the entire marketplace.
Okay, that makes sense. So now let's fast forward a few decades. From 1956 to 1992, we get the big one, the SEBI Act.
The SEBI Act of 1992. This really is the origin story of the regulator as we know it today. Before this, regulation was fragmented. The SEBI Act established the Securities and Exchange Board of India and its preamble, which is like its mission statement. It has three pillars. You should know these.
Okay, I'm going to guess. First one has to be protect investors.
That's number one, to protect the interests of investors in securities. Number two is to promote the development of the securities market.
Promote it. That's interesting. I usually think of a regulator as a police force, not a growth engine.
And that's the unique dual mandate of SEBI. They have to police the market, but they also have to grow it. They want more people investing. They want deeper markets, but they want it all done safely. And number 3, of course, is to regulate the securities market. So protect, promote, and regulate.
Protect, promote, regulate. Got it. But then the text lists.
Yeah.
Wow. It looks like the entire alphabet. Items A through O. These are the specific functions of SEBI. This is a long list.
It is a long list, but we need to walk through them because an exam question could easily be, which of the following is not a function of SEBI? So let's break them down one by one. I'll translate the legalese into what it actually looks like in the real world.
All right, let's do it. Item A.
Okay, A. Regulating the business and stock exchanges and any other securities markets. We just talked about that. SEBI is the boss of the exchange. They set the trading hours, the circuit breakers, the rules of the game.
Makes sense. Item B.
B. Registering and regulating the working of intermediaries. This is your stockbrokers, merchant bankers, portfolio managers, and yes, the reason we're here, investment advisors. If you are a middleman touching client money or influencing their decisions, SEBI regulates you.
So basically anyone between the investor and the market.
Pretty much.
Okay.
Item C.
Go ahead.
Registering and regulating the working of depositories, participants, custodians, and so on. In simple terms, that's NSDL and CDSL, the people who actually hold your shares in DMAT form. SEBI makes sure that vault is secure.
Okay. Item D.
Registering and regulating venture capital funds and collective investment schemes, or CIS. That category includes mutual funds. Basically, if you are pooling money from the public to invest it, SEBI regulates how you ask for that money and where you put it.
Item E.
Promoting and regulating self-regulatory organizations, or SROs.
Self-regulatory. That sounds a bit like letting the fox guard the henhouse.
Hey, it's more like the sheriff deputizing a posse. These are industry bodies, like AMFI for mutual funds, that police their own members, but they do it under SEBI's ultimate supervision.
Got it. Okay. Item. This one sounds big.
It is. Prohibiting fraudulent and unfair trade practices relating to securities markets. This is the big no cheating rule. They have a whole set of regulations for this, the PFUTP regulations, which we'll get to in a minute.
Okay.
Item G. Promoting investor education and training of intermediaries.
So this deep dive, this NISM certification.
Yeah.
This is literally SEBI fulfilling its mandate under Item G.
That's exactly right. This is part of that mandate. Okay, next is H.
Prohibiting insider trading. The classic movie crime.
Yep. We'll dive deeper into that one, too.
Regulating substantial acquisition of shares and takeovers.
Right. So if a big company wants to buy another publicly listed company, SEBI sets the rules to make sure the small retail shareholders don't get crushed in the process.
Okay, well,
Calling for information from, undertaking inspection, conducting inquiries and audits at the stock exchanges, intermediaries, SROs.
Pretty much everyone.
so they have subpoena power, basically.
A very powerful version of it. You can't say that's private to SEBI. If they ask for information, you give it.
All right. Item K.
Performing such functions and exercising such powers under the provisions of the SCRA in 1956 as may be delegated to it by the central government. So sometimes the government just says, hey, SEBI, you handle this part of the SCRA for us. It's delegation, levying fees or other charges for carrying out the purposes of this section.
So they fund themselves.
In part, yes. SEBI has to keep the lights on, so they charge fees for registration, filings, things like that.
Yeah.
Conducting research for the above purposes. You can't regulate a market you don't understand. Calling for information from other agencies, whether in India or abroad, that are necessary for its functions. So they can coordinate with, say, the RBI, or even a foreign regulator like the SEC.
And finally, the catch-all.
Performing such other functions as may be prescribed, the anything else we forgot to list clause.
Wow. Okay, so they basically have their hands in everything related to the market.
They absolutely do. And along with those functions come the powers. The power to impose penalties, the power to initiate what's called adjudication. If you default on any provision like failing to furnish information or failing to enter into a proper agreement with a client, SEBI can come after you legally and financially.
Okay, so let's double-click on that fraud part you mentioned.
Yeah.
That was Item F, Section 18.3, the SEBI PFUTP Regulations, 2003.
Right. Prevention of fraudulent and unfair trade practices. Now, most people think they know what fraud is. You know, I stole money. But the regulation is much, much broader. It defines fraud as any act, expression, omission, or concealment that is committed to induce another person to deal in securities.
Wait, omission or concealment? So just staying silent about something important can be fraud.
Absolutely. If you know a material fact, let's say you know a company is about to lose its biggest contract, and you actively hide that fact from someone you're advising to buy the stock, that's fraud.
Wow.
But here is the really important nuance, and this is a major concept you have to grasp. The regulation says it is immaterial whether there was any wrongful gain or avoidance of any loss.
Hold on, really? So if I try to run a scam in the market, but I'm just really bad at it and I actually lose money,
Yeah.
I still committed fraud.
Yes. The outcome doesn't matter. The intent and the act do. Whether you made a crore or lost a crore, if you engaged in what the law calls willful misrepresentation, if you suggested a fact that you knew to be false, or if you made a promise with no intention of performing it, that is fraud.
Empty promises. That sounds like a bad relationship.
In the market, it's a crime. Another one listed is reckless representation. This one's subtle. Even if you didn't know for a fact that what you were saying was false, if you were just reckless and careless about whether it was true or not, you're still on the hook.
You have a duty to be careful with your words.
A very high duty. Okay, so that's fraud. Now let's talk about the people in the middle. Section 18.4, the SEBI intermediaries regulations from 2008.
And this sets out the code of conduct, right? The rules of engagement for anyone who is an intermediary.
Exactly. And remember, an investment advisor is an intermediary, so this code applies directly to you. It's broken down into a few parts.
The first one is investor protection.
And this is the golden rule. It says, an intermediary shall render the best possible advice to its clients, having regard to the client's needs. Your needs, the client's needs, come first. Always. The code also demands high standards of integrity, fairness, and efficiency.
And it mentions due diligence.
Right. You must exercise due diligence and you can't collude with others. You have to use your own independent professional judgment. You can't just recommend a stock because your buddy at another firm is recommending it. You have to do your own homework.
Okay, here's one that looks like a very practical, testable rule.
Yeah.
Fees.
Flag this for the exam. Listen closely. An intermediary shall not increase charges or fees for the services rendered without proper advance notice to its clients. You can't just quietly bump up the bill and hope they don't notice.
So you have to send an email or a letter saying, as of next month, our fees are changing.
Exactly. Transparency in billing is absolutely non-negotiable.
Okay, that seems fair. Then there's a section on dispersal of amounts.
Simple enough. If you are holding money that belongs to a client, dividends that have come in, interest payments, you have to pay it out to them promptly. You can't sit on it to earn a little extra interest for your own firm.
Right. And then dispersal of information.
Again, transparency. Make adequate disclosures. No misrepresentation. And here's a big one. You cannot make exaggerated statements, whether you say them orally or you put them in writing.
So no, this stock is a 10-bagger, guaranteed, it's going to the moon.
Exactly that. You cannot say things like that unless you have extremely hard, verifiable data to back it up. And even then, you need to be very, very careful with your language and include all the risks.
And what about confidentiality?
Strict confidentiality. Unless the law requires you to disclose it, you cannot blab about your client's portfolio, their financial situation, anything to your friends at the gym. It's their private information.
Got it. Okay, now let's talk about the one that everybody knows from the movies. Section 18.5, the SEBI Prohibition of Insider Trading Regulations, 2015.
Right. And the definition here is really built on two key concepts, the insider and the UPSI.
UPSI, that stands for Unpublished Price-Sensitive Information.
Correct. It's any information that is not yet public, but if it were to become public, it would materially impact the price of the stock. Think quarterly earnings results before they're announced, news of a big merger, a major contract win or loss.
And an insider is who? Just the CEO.
It's much broader than that. An insider is defined as any person who is a connected person or someone who is in possession of or has access to that UPSI.
So it could be the CEO's assistant or the lawyer working on the merger deal.
It could be the printer who is printing the annual report and sees the numbers early. If you have the information, you are an insider.
So what is the actual offense?
The offense is using that UPSI to get an undue advantage for yourself or someone else. If I'm the CFO and I know our quarterly earnings are going to be double what the market expects, that's UPSI. If I go out and buy a ton of stock before that news is released, that's the crime.
And it's not just trading, right? It's also communicating.
Yes, that's a critical point. The regulations say you cannot communicate, provide, or allow access to any UPSI to any person, including other insiders, unless it's for a legitimate business purpose.
So tell my brother-in-law over dinner, hey, you should buy some stock in my company, something big is coming. That's a crime.
That is a crime, even if you don't buy a single share yourself. You tipped him off, you are both liable. The goal is to maintain a level playing field and protect market integrity.
Very clear.
Yeah.
Okay, now we're arriving at the main event, Section 18.6, the SEBI Investment Advisors Regulations 2013.
This is it. This is the deep end of the pool. If you are taking the NISM Series XA exam, this is your world. These regulations define your existence as a professional.
All right, let's start with the definitions in 18.6.1. First up, assets under advice. What does that mean exactly?
It means the aggregate net asset value, or NAV, of all the securities for which you have rendered investment advice. And this is important. It doesn't matter if the client executed the trade through you or through some other broker. If you advised on it, it counts towards your assets under advice.
Got it. Okay, next one, family of client. This seems very, very specific.
It is, and it's a common point of confusion. So picture a family tree. You have the individual client at the center. Now you draw a circle around their spouse, their children, and their parents. But T, and this is the key, you only include them in that circle if they are financially dependent on the client.
So what about my adult son, who has his own job and lives in another city?
Not part of the family of client under this specific definition because he's not dependent.
What about my brother who lives with me but has his own income?
No. Siblings are not included in the definition at all. It's just spouse, children, and parents, and only the dependent ones.
So for exam purposes, individual client plus dependent spouse plus dependent children plus dependent parents.
You've got it.
Okay. Now, the big one. What actually counts as investment advice?
The definition is broad. It's any advice relating to investing in, purchasing, selling, or otherwise dealing in securities or investment products. And very importantly, it specifically includes financial planning.
So if I'm helping someone make a comprehensive financial plan, that falls under these regulations.
100%.
What is not investment advice? This seems just as important to know.
It is. This is crucial. If you write an article in a newspaper, or you go on a business TV show, or you write a blog post that is widely available to the general public, that is not considered investment advice under these regulations.
Why not?
Because it's not personalized. It's for the masses. Investment advice, in the eyes of the regulator, is specific advice given to a specific client based on their specific situation. Also, advice given by, say, a lawyer or an accountant that is incidental to their main practice isn't covered here.
Okay, that makes sense. Moving on to Section 18.6.2, registration. The rule here seems pretty simple. No person can act as an IA without a certificate of registration from SEBI.
Correct. No certificate, no business. End of story.
But there are exemptions, right?
Yeah.
Section 18.6.3, who gets a pass?
Yes, there's the list. But it's usually because they are already regulated somewhere else or their advice is very limited. So, for instance, an insurance agent. They're exempt, but only if they are advising solely on insurance products.
Same for a pension advisor.
Exactly. Then you have mutual fund distributors. They can provide advice that is incidental to their main job of distributing funds, but they cannot charge a separate advisory fee. That's the line. Also exempt are lawyers and accountants. Again, if the advice is just incidental to their legal or accounting practice. Portfolio managers and fund managers are also exempt because they're already registered under different and often stricter SEBI regulations.
Is there anyone else?
Yes, one more specific one. If you are a person giving investment advice exclusively to clients who are not residents of India, so foreign clients, NRIs, PIOs, you are exempt from these specific IA regulations.
Okay, that's a good list to remember. Now, let's say I do want to register. I don't fit any of those exemptions. What do I need? Section 18.6.4, qualifications and certification.
All right, major exam flag here. This is a guaranteed question area. To become an individual investment advisor or to be the principal officer of an advisory firm, you need two things: a specific level of education and a certification.
Okay, let's break down the education part first. What kind of degree do I need?
You need a professional qualification or a postgraduate degree or postgraduate diploma in one of these fields. Finance, accountancy, business management, commerce, economics, capital markets, banking, insurance, or actuarial science. And that course has to be at least 2 years long.
So an MBA in finance would work.
Perfect example.
What if my master's is in, I don't know, English literature? Am I out of luck?
Not necessarily. There's an alternative path. You can still qualify if you have a graduate degree in any discipline.
So the English lit degree is fine.
PLUS, 5 years of relevant experience. And that experience has to be in activities relating to advice in financial products or in securities or portfolio management.
Okay, so either a relevant master's degree or any bachelor's degree plus 5 years of solid, relevant experience.
Correct. And on top of that, regardless of your degree, you need the certification.
Which is the NISM Series XA and XB certification, the very exam we're talking about.
The very one. And you have to keep it current. The rules say you must obtain a fresh certification before the validity of your existing one expires. No gaps allowed.
All right, let's say I've got my qualifications, I've passed the exam, I get my certificate. What are the conditions that come with it? Section 18.6.5.
First condition is about your name. You must use the term investment advisor in all your correspondence and communication. If you are an individual, it has to be part of your business name. If you're a big corporation, it has to be in the name of the specific department that provides advice.
And there's a limit for part-time advisors, right?
Yeah, it sounds important.
Major exam flag. Write this number down. If you are a part-time investment advisor, meaning this isn't your primary profession, the regulations are very clear. The number of clients you can have shall not exceed 75.
75, that's a hard cap.
It's a hard cap. If you get client number 76, you either need to stop taking on new clients or you need to make this your full-time job and meet the full-time requirements.
Okay. What about for a corporate IA, like a bank? For a corporate body, they must have a separately identifiable department or division for investment advisory services. It can't just be some random person in the marketing department also giving advice.
There have to be walls around it.
Exactly. And speaking of financial backing, Section 18.6.6 mentions a deposit. You have to maintain a deposit as specified by SEBI, which acts as a form of security.
Okay, let's move to 18.6.7, general obligations. We already talked about acting in a fiduciary capacity. But there's a very specific rule in here about own account trading.
Yes, and this is to prevent front-running your own advice. The rule says an investment advisor shall not enter into transactions on his own account, which are contrary to the advice given to clients for a period of 15 days from the date of such advice.
Could you break that down? Contrary to advice. So if I tell a client to BUI a stock, I am not allowed to sell that same stock from my personal account for 15 days.
That's precisely it. It would be a huge conflict of interest. But there's a flip side. If your personal situation changes, and you have a genuine reason to make a trade that might seem contrary, you must inform the client of this at least 24 hours in advance.
So, hey client, I know I told you to hold this stock for the long term, but due to a personal emergency, I need to sell my shares tomorrow.
Yes. Again, it all comes back to transparency. And of course, KYC is mandatory. You have to know your client.
Okay, let's talk money. Fees. Section 18.6.8.
Right. You are a professional. You are entitled to charge fees for your service. That's the business model. But there are strict limits.
That's the mean one.
Flag this for the exam. You are allowed to charge fees in advance from a client. However, that advance shall not exceed the fees for a period of 1 year.
So no 5-year upfront non-refundable subscriptions.
Absolutely not. You can only bill for a maximum of 1 year in advance.
And do these fee rules apply to everyone?
Good question. The text notes that the specific limits on fees, the modes of payment, refund policies, and so on, they apply strictly to individual clients and HUF, or Hindu Undivided Family, clients.
So the retail crowd.
Exactly. The protections are for them. If your client is a big corporation or what's called an accredited investor, the rules on fees are more flexible because they are assumed to be more sophisticated and able to negotiate their own terms.
Okay, so before I can even give advice and charge fees, I have to know who I'm talking to. Section 18.6.9, risk profiling.
This is non-negotiable. It is mandatory. You cannot prescribe medicine without a diagnosis, and you absolutely cannot give investment advice without a comprehensive risk profile.
And what goes into that profile?
You need to assess 2 key things. 1, the client's capacity for absorbing loss. That's their financial ability. How much can they actually afford to lose without it derailing their life?
And number 2?
The client's willingness to accept loss. This is their psychological attitude towards risk. Someone might be a millionaire, so they have the capacity, but they might be extremely risk-averse and lose sleep over a tiny drop in their portfolio. You have to know both.
And the main tool for this is a questionnaire.
Yes. And the regulation specifically warns that the questionnaire must be fair, clear, and not vague. You can't ask leading or tricky questions designed to push them into a high-risk bucket just so you can sell them risky products.
Right. Once you have that profile, you move to the next logical step. Section 18.6.2, Suitability.
Suitability is the bridge. It connects the client's risk profile to the investment product you recommend. The advice must fit the profile. It's that simple. If you have a conservative retiree who needs income, you cannot recommend a high-risk, non-dividend paying microcap stock. It is not suitable.
And you have to be able to prove it's suitable.
Right. Yes. You must document the process. You need to have a reasonable basis for your recommendation. You should be able to write down, I recommended this fund because it aligns with the client's goal of X and their risk tolerance of Y.
What about for more complex products?
The bar is even higher. If you're recommending derivatives or structured products, you really need to have a solid, documented basis for why that complex solution is suitable for that specific client.
Okay, 18.6.11 is disclosures to clients.
Before a client even signs on the dotted line, they need to know everything about you. You have to disclose your qualifications, your experience, any disciplinary history you might have, any affiliations with other companies, and, critically, any conflicts of interest.
For example, if I'm recommending a stock that I also happen to own personally,
You must disclose that holding or position. The client has a right to know that you stand to gain personally if the stock goes up.
makes sense. Section 18.6.12, record maintenance. This sounds like an exam question.
It is. So, exam flag. How long must an investment advisor maintain records?
I'm going to guess 5 years. That seems to be a common number.
You got it. 5 years. You need to keep all your records for a minimum of 5 years.
And what records are we talking about?
It's a long list. All your KYC records, the risk profiles for every client, the written agreements, copies of the advice you provided, and this is huge, the rationale for your advice. You can't just have a record saying, told client to buy Apple. You have to have a record that says why you told them to buy Apple, and that rationale needs to be signed and dated.
So all your homework.
All your homework, plus copies of all your communications with the client, emails, letters, maybe even summaries of important phone calls.
And this all gets audited.
Yes. You need to conduct a yearly audit by a qualified chartered accountant or a company secretary to ensure you're complying with these regulations.
Okay, section 18.6.13 mentions a compliance officer.
This is mandatory if you are a non-individual IA, so a firm or a company. You must designate a specific person as the compliance officer. Someone's job has to be making sure the firm is following all these rules.
All right. Now, section 18.6.15. This looks complicated. The heading is client-level segregation of advisory and distribution activities.
This is a critical and relatively recent development. It's all about tackling the inherent conflict of interest between advising a client and distributing a product to them.
The old model where you advise a client to buy a mutual fund, and then you also earn a commission from the mutual fund company for selling it.
SEBI wants to kill that model. So they've put in some very strict rules. Rule number 1, an individual investment advisor cannot provide any distribution services at all. You have to choose your lane. You are either a fee-only advisor or you are a commission-based distributor. You cannot be both.
Can't wear two hats.
Not anymore. Rule number 2 extends this to your family. The family of an individual IA cannot provide distribution services to the IA's advisory clients.
So you can't just say, I'll give you the advice and now please go buy the product from my wife's distribution firm.
Exactly. They closed that loophole.
Okay, but what about a big bank? A non-individual entity. They have both advisory desks and distribution teams.
They can continue to do both, but they must segregate these activities at the client level. This is the key phrase. It means for any single client, say client A, you can either be their advisor or their distributor. You can't be both. You cannot earn an advisory fee, A&D, a distribution commission from the same client.
So client A pays me an advisory fee, client B doesn't, but I can earn commissions on products I sell to them.
Precisely. You have to keep the revenue streams and the services completely separate for each client. The regulation also talks about maintaining an arm's-length relationship between the advisory department and any other activities within the firm.
It's all about preventing that double dipping.
That's the entire point.
Okay, section 18.6.1c brings up the code of conduct again, this time specifically for IAs, as listed in the third schedule of the regulations.
Right, and it reinforces all the principles we've discussed. Honesty, fairness, diligence, acting with the requisite capabilities, and again, a big focus on conflict of interest. Avoid it if you can. If you can't, you must disclose it fully.
And then there's the investor charter in 18.6.18.
This is a document that SEBI put out and that IAs need to be aware of. It's a simple list of dues for investors, like always verify the IA's registration on the SEBI website and pay all fees through proper banking channels.
And the don'ts.
Things like don't fall for promises of guaranteed or exorbitant returns, and don't share your login credentials or OTPs with your advisor. It's basic financial hygiene.
Is there anything testable in this section?
Yes. Exam flag. The charter mandates that investment advisors must disclose data on complaints they've received on their websites, and they have to update this by the 7th of the succeeding month.
By the 7th. Got it.
Okay.
Okay, finally, for this massive IA section, 18.6.21 talks about administration. Who's actually watching the watchers? Who supervises the IAs?
SEBI has recognized a subsidiary of a stock exchange to handle the day-to-day administration and supervision of investment advisors. As of now, that body is BASO, which stands for BSE Administration and Supervision Ltd.
And are there specific criteria for a body to be able to do this?
Yes, and these numbers are testable. So, final exam flag for this section. To be recognized as this supervisory body, the entity must have 1. Been in existence for at least 15 years.
50 years.
2. Have a net worth of at least INR 200 crores.
200 crores.
And 3. Have nationwide terminals and presence.
15 years, 200 crores, writing that down. Okay. We have survived the IA regulations. That was intense.
It was, but as an aspiring IA, that is the bulk of your legal and ethical responsibility. The rest of this chapter covers the other major laws that you will bump into in your career.
Okay, like Section 18.7, the Prevention of Money Laundering Act, or PMLA, from 2002.
Right, and the goal here is pretty simple: to stop dirty money that comes from criminal activity from being disguised and integrated into the legitimate financial system as clean assets.
What's the definition of the offense?
It's very broad. It's whosoever directly or indirectly attempts to indulge or knowingly assists or is a party to any process connected with the proceeds of crime, including its concealment, possession, acquisition, or use.
And as an intermediary, an IA is a reporting entity, right? So I have obligations under Section 12 of the Act.
You do. You have 3 main obligations. 1, maintain records of all transactions for a period of, you guessed it,
5 years.
5 years from the date of the transaction. 2, you must furnish any information the director of the Financial Intelligence Unit asks for. And 3, you must verify the identity of your clients. This is your KYC obligation, which is now linked to Section 12 ABLE, which specifies using AHAR or other official verification modes.
And we have to be on the lookout for suspicious stuff.
Yes. The guidelines specify certain transactions to monitor: large cash withdrawals or deposits that exceed certain limits, high-value international remittances, and any transaction that seems suspicious.
What's an example of a suspicious transaction in our context?
If a young college student with no declared source of income suddenly wants to invest 50 lakhs through you, that's a suspicious transaction. You have a legal obligation to file a suspicious transaction report, or STR, with the FIU.
Got it. Okay, let's do a quick lightning round on Section 18.8, the other acts. Just the key purpose and application for each. First up, FEMA, 1999.
Foreign Exchange Management Act. It controls the inflow and outflow of foreign currency. The key concept is the distinction between a resident and a non-resident. Its main application for you is when clients want to buy foreign stocks through the LRS scheme, or when there's foreign direct investment, FDI, coming into India.
Okay. The Indian Contract Act, 1872.
This is the foundation of all business agreements in India. The essentials of a valid contract are offer, acceptance, free consent, a lawful object, and the parties must have the capacity to contract. Your advisory agreement with your client is a legally binding contract governed by this act.
The Guardian and Wards Act, 1890.
This deals with investments for minors, who are persons under the age of 18. It defines who a guardian is, the caretaker of the minor or their property, and Section 7 gives the court the power to appoint a guardian if needed.
The Negotiable Instruments Act, 1881.
This governs instruments like checks and promissory notes. You should know the basic definitions. Section 4 is a promissory note, Section 5 is a bill of exchange, and Section 6 is a check, which is specifically a bill of exchange drawn on a specified banker.
The Insolvency and Bankruptcy Code, or IBC, from 2016.
A very important modern law. It consolidates all the different laws on insolvency and reorganization. The key definition for you is what it means to be bankrupt. A debtor who has been adjudged as bankrupt by a formal bankruptcy order from an authority.
And finally, FATSIA and CRS.
These are global tax regulations. FATSIA is a U.S. law, the Foreign Account Tax Compliance Act, designed to prevent tax evasion by U.S. citizens using foreign accounts. CRS is the Common Reporting Standard, which is basically the global version of FESA.
And how does that impact me as an IA in India?
It means you have an obligation to identify if any of your clients are a U.S. person for FESA purposes or a tax resident of any other foreign country for CRS purposes. If they are, you must collect that information and report it up the chain so that it be shared with the respective tax authorities.
Okay, that is a comprehensive regulatory landscape. To close this all out, Section 18.9 gives us a couple of case studies that don't do this segment.
These are real-life examples of what happens when you ignore the rules we just discussed.
Case 1 is about registration for IAs.
Right. The scenario was an entity that was providing trading tips and stock advice to investors without being registered with SEBI as an investment advisor.
And the takeaway?
The takeaway is simple. If you act like an IA, if you provide investment advice for a fee, you must register. SEBI took action against them because misleading investors and operating without a license creates huge systemic risk.
Okay, and case 2 is about false credentials.
This was a firm that was marketing free trials, then spamming clients with tips and pressuring them to pay high fees, all while falsely claiming on their website that they were registered with SEBI.
And the lesson there?
SEBI takes these prima facie violations, things that are obviously wrong on the surface, very seriously. They came down hard on them. And a key red flag mentioned in the case was the promise of exorbitant returns on a meager investment. That kind of language is a huge warning sign for regulators and investors alike.
So the lesson from both cases is pretty clear. Get registered, tell the truth about who you are, and do not overpromise.
That sums it up perfectly.
All right, we have unpacked the entire chapter. Let's do a final pre-exam check. What are the key numbers I absolutely need to have on my cheat sheet going into the exam hall?
Okay, let's do a rapid-fire review of the flagged items. Ready?
Ready?
Record maintenance period for an IA.
5 years.
The client limit for a part-time IA.
75.
The two main criteria for the supervisory body, BASO.
15 years of existence and a net worth of 200 crores.
Perfect. The maximum period for which you can charge advance fees.
1 year.
The deadline for disclosing complaint data on your website.
By the 7th of the next month.
And the trading ban. The number of days you can't trade contrary to your advice.
15 days. And you have to give 24 hours notice if your situation changes.
Excellent. You've got them all.
You know, at the start of this, I called this driver's ed. And it felt like just a bunch of rules to memorize. But after going through it all, these regulations don't just feel like rules to stop us from doing things. They feel like the very framework that allows this to be a real profession.
That is the perfect way to look at it. Without these rules, being an investment advisor would be a meaningless title. It would just be people shouting tips in a bazaar. These regulations, this code of conduct, it gives the title weight. It builds trust. It creates legitimacy.
Well said.
Yeah.
Well, for everyone listening, good luck with the exam. You have the knowledge now. You just have to go and apply.
You've got this. Study hard.
We'll see you on the next Deep Dive.